Are you or a loved one disabled? Do you feel alone, lost, and confused as to how to win your Social Security case? If you're watching this video, it's probably because you have so many questions and you're desperately looking for the answers. Hi, my name is Avi Leibovic, and I'm the owner at Benefits for All and the lead attorney at Avi Leibovic Associates. Over the course of my 20-year career, I've overseen the processing and screening of over 500,000 disability cases, working with the largest hospitals, neighborhood clinics, primary care physicians, and even individuals who had no access to care at all. My strategies for how to win the case have made me one of the top experts in Social Security law in the entire nation. My life and my career were going great. And then one day it all came crashing down. It started first with some abdominal pains. And before I knew it, I'd been admitted to the hospital several times and I required multiple surgeries. I found myself unable to work and disabled and in desperate need of my own benefits. I understand exactly how you feel. I was in your shoes. And I'm going to take you through the process and help you and give you everything that I know so that you can win your case. I'm recovered and I'm back at work. And I have a newfound passion for helping disabled people because I myself have been there too. Call our office today for a free screening and to see how we can help you with your Social Security case. At the same time, enjoy these videos and webinars that we've prepared to help you understand how to win your Social Security case. Hi everyone, this is Avi Leibovic and you're watching another amazing webinar brought to you by Benefits for All, where we teach you how to win your Social Security disability case without having to pay the costs of an expensive attorney. I'm in Amarillo, Texas, right along historic Route 66. And not too far down, you have the Cadillac Ranch art display. You guys can watch the webinar on that. It's about overcoming fear. And now over here, we're standing in front of the RV Cadillac park. And in front of us we have a couple Cadillacs, and we also have Second Amendment Cowboy. For those of you who are into politics, we're not going to get too into politics, but Second Amendment is the right to bear arms. We're in Texas, right? Texas, to quote George Bush, I'm going to get my gun, right? Going to get my gun, smoke him out, Osama bin Laden. But we're not about the politics. We're not about Bush. We're not about Trump. We're not about Hillary. We're not about, Bernie Sanders. We're just right now all about the U.S. Constitution, due process. Just like the Second Amendment is part of the U.S. Constitution, we all have to understand that the Fifth Amendment and the 14th Amendment, both the Fifth and the 14th Amendment, give every person what they call due process rights. The Fifth is for federal, the 14th is for state. So what does it mean, due process rights? That means that something that you are entitled to cannot be taken away by the government without giving you first due process, right? There has to be some level of process that's over here. It can't be arbitrary and capricious the way they go ahead and make a decision. I like you, you're approved. I like you, you're denied. I like you, you're approved. I like you, you're denied. I don't like you, you're denied. It doesn't work like that, okay? So we need to have due process, and in most cases we do have due process because you have the hearing before an administrative law judge. But this webinar, the topic really is prototype offices. Prototype offices. You say, oh, hold it right there. We don't know anything about prototype offices. I've been watching a lot of your webinars. You never mentioned anything about a prototype office. What is this prototype office discussion about? Okay, so let's talk about what a prototype office is. Let's start with the basic rule. What's the basic rule? Everyone knows this and should remember it from the webinars. You have an application. If it gets denied, you have a request for reconsideration. If the request for reconsideration gets denied, you have the request for a hearing before administrative law judge, right? Really easy. Application, reconsideration. But in late 2000, right? I know, it's 2016 now. She's talking about 16 years ago, right? I've been doing this for longer than that. But in 2000, Social Security changed their rules. And what they did was they went ahead and in certain regions, certain areas, not every area, in certain regions, they decided to try a new process, right? And then the process would cut out the reconsiderations, would cut them out, right? And instead of having a reconsideration, you would have something where the disability analyst who was reviewing the medical records and reviewing your case, they would call you for a pre-decision conference or pre-decision meeting, however they call it. And what they hoped was that they could save money with the judges, and they hoped that they could reduce the number of cases that were going to the judges if they went ahead and they had this face-to-face or telephone call, or however you want to do it, pre-decision meeting, right? So again, ordinarily on the regular system, right, you have application, reconsideration, and hearing. Under these prototype offices, right, a prototype is something new, right? You have just the application, you have no reconsideration. You skip the reconsideration, and instead, at the end of your application, they go ahead and they call you up, and they set up a pre-decision meeting to talk with you about your case, interview about 15, 20 minutes, and then you go straight to hearing, okay? Straight to hearing, right after the application. That's a prototype office. Now, how do you know which region you're in? How do you know which area you're in? Are you a prototype area? Are you a non-prototype area? Do you have application, recon, and hearing? Or do you just have application, and then the pre-decision conference, and then boom, a hearing? How do you know? Well, first you can go on www.ssa.gov and you can check it out. Secondly, you can go on www.and-benefits-for-all. We'll have it listed over there too, which are prototype offices and which are regions and which are not prototype regions. Or third, you can just go to Google or Bing or whatever search engine you use, and you could just write SSA prototype office, locations, and it will come up. But that's not really what this is about, because we're in front of our Second Amendment guy here. And we spoke about what? We spoke about the 5th and the 14th Amendment providing due process. So let's talk about that due process. Due process doesn't just mean that you get to go before a judge. It doesn't just mean that they can take your benefits away or decide arbitrarily, I like you, I don't like you, I like you, I don't like you. It really gives you much, much more. It gives you the right to have a fair process, and you're entitled to have an attorney by your side, right? So the regular course is that a person has an application, they have a reconsideration, and then they usually bring an attorney in to really get involved at the end by the hearing. Now, is that the best practice? I don't think that that's the best practice, because you should have an attorney involved all the way from the beginning, from the application. Unless you're watching these webinars, and then I'm teaching you everything that I know, right? So you don't need the attorney anymore, and you're gonna save all that money, thanks to benefits for all. But there is something to be said about the 5th and 14th Amendment and due process as it relates to a prototype office. Why? Because we said a prototype office goes from an application denial straight to a pre-decision conference and then to a hearing. So let's assume now that we want to incorporate a little bit more due process into that pre-decision conference. How do we do that? The Social Security worker, the disability analyst is calling you up and saying, hey, we have your case, we've reviewed it, we kind of like it, we have some questions, there's some things we're not sure about, we need you to come on in, or we need to set up an appointment 20 minutes on the phone, and we need to have a discussion about your case. And right there, hopefully we'll be able to get it approved, because we want to save the number of cases and eliminate the number of cases and the high volumes that are going to the judges, save some money for the budget, and hopefully we can resolve it. And the truth is, it's a very good way to go ahead and work with the person. What do you need? Can I get it for you? Ask me any question you want. I'll provide you with an explanation, or I'll go to a doctor and I'll get supporting evidence. It's actually a pretty good method if you know how to use it. But back to the due process. Most claimants will not incorporate their attorney in that pre-decision conference. They'll just say, oh, wait for the hearing. I can handle the pre-decision conference on my own. Wrong, 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 wrong. Due process. You understand that if you get that application denied, and at the pre-decision conference, so to speak, you're not able to successfully persuade the analyst that you should be disabled, you're now going to have to wait a year or more for a hearing. And you don't want to wait a year or more for a hearing, because it's a year on top of the application, which was 6 to 9 months. What do you want to wait for? You want to wait 18 months? You want to wait 20 months? 22 months? 24 months? Right? You're sick. You need the help now. You need the benefits now. You need to pay rent. You need to buy medicine. You need to pay for food. You need to pay for utilities. Right? You can't mess around. So my suggestion to all of you is, first off, if you're representing yourself, right, download the webinars. Watch this one about prototype offices so you understand how the prototype office is a little bit different. You're going to go on the internet and you're going to check if you're in a prototype region or not. You're going to maybe call that district office to see if you're in a prototype region or not. But most importantly, you're going to read the letters that are sent to you. I can't tell you how many claimants I have, how many clients I've had over the years who just don't read. They get the letter, it says Social Security Administration, they kind of just like throw it up in the air, I don't know, whatever. Read the letter. Because at the end of the application, right, when it gets denied, it's going to give you instructions if your next step is meeting with an analyst, or if your next step is going ahead and requesting a reconsideration. Right? If you're in a regular region, you're going to go from application to reconsideration to hearing. If you're in a prototype region, you're going to go from the application to this pre-decision, right? Then you're going to look at your paper and determine exactly which region you're in and the instructions that are there to see if you have to make a conference with them or if you should go straight to the hearing, right? Or request a recon. You need to read the paper. But you need to get the attorney involved in the beginning. So like I said, if you are downloading these webinars and you're reading them, then you should have, I'm going to give you, by the time you're done with me, believe me, I'm going to give you everything that I know, and you should have enough that you're able to go out and you're able to discuss intelligently and coherently and methodically to discuss your case. You know what's wrong with you. You know when it started. You know how you feel. You know who your doctors are. You know what medications you take. You may not be a doctor, but you've spoken to your doctor, so you don't need to know everything about the medical records, but you need to know enough about how the medical records are set up and what they say to have a conversation. I think that you'll be able to do that. But if you are taking an attorney, don't wait till just the hearing to bring your attorney in for the due process. The due process began all the way in the beginning. They can't even deny the application without sending you a proper letter with instructions on how to appeal. If they just deny you, that's a violation of due process. It's against all the Social Security rules and regulations and policies. Social Security was set up, and all the government agencies were set up, with due process in mind, to make sure that every person is protected and that every person is receiving justice, right? With liberty and justice for all, right? We're on benefits for all, because we want to make sure that you're having all of the policies, regulations, and procedures enforced on your side, protecting you, to make sure that you have fair process, due process, to obtain your benefits. So what's the takeaway from this? The takeaway from this is, number one, you're going to go ahead and you're going to figure out, am I a prototype office or am I not a prototype office? Number two, you're going to go and understand a little bit more that prototype means what? There's no reconsideration. You're just going from application straight to some type of pre-decision, conference, meeting, and then to the hearing. Whereas a prototype office, like that's what you do in a prototype office, whereas the regular office is you go from an application to a recon to a hearing. You're going to read the letters to determine exactly which region you're in. The letters will tell you clearly what the next step is. You're going to look online if you're able to get access to an internet, go to your public library or borrow your friends, or ask to borrow your friend's phone. These days, most of the smartphones have it. And you're going to go to www.ssa.gov, or you're going to go to Google and you're just going to write SSA or Social Security Administration prototype offices, locations. Those three words is going to come up, right? And then you're going to go ahead and you're going to feel confident and you're going to feel good and you're going to say, aha, I know this system so well because my friend Avi Leibovic taught me about prototype offices and non-prototype offices. I'm telling you, you're going to know more about this than probably most of the attorneys that are out there who are just trying their best. They're good guys, good ladies, they're just trying their best, but they really don't know what they're doing. It's a trial and error. And you're, at times, sometimes you're just a guinea pig to see if they can successfully win the case. And many times they didn't even do anything to win the case. Your medical condition won the case for you. They were just kind of standing along and pushing the paperwork along. And I'm telling you, I'm going to teach you how to do the paperwork. You're going to be able to do it. You're going to collect your medical records. You're going to keep getting treatment. You're going to know what if you're a prototype or non-prototype office. You're going to make sure the 5th and 14th Amendment due process is being given to you. We're going to remember our cowboy friend, the Second Amendment. He's got a serious face over there, right? George Bush, going to get my guns, right? Smoke them out. And that's what makes America, that's what makes the United States of America the greatest country in the world and through all of history. Because there's justice, there's fairness, there's equality, right? No one is better than the other person. And every person has the same shot. Government cannot take away your benefits without making sure that you have due process, okay? I know this is a little bit of a more difficult conversation and a little bit more of a difficult concept. Just figure out if you're a prototype office or a non-prototype office, and then you'll know whether you need to submit a reconsideration request or whether you can go straight and make an appointment with the disability analyst to have a pre-decision conference with them.